What are the differences in international family law petitions? Imagine trying to piece together a puzzle that crosses borders, languages, and legal systems. That's what international family law petitions often involve. They are legal requests filed in courts to handle family matters that involve more than one country. But not all petitions are the same, and understanding their differences can help you navigate the process smoothly. First, let's look at immediate relative petitions. These are used when a U.S. citizen wants to bring close family members into the United States. Only U.S. citizens can file these petitions. They include spouses, children under 21 years old who are unmarried, and parents of U.S. citizens who are at least 21. The big advantage here is that once the petition is approved, the family member does not have to wait for a visa number. The visa becomes available right away, speeding up the process. This means less waiting time and quicker reunification. Now, compare that with family preference petitions. These are more common and involve both U.S. citizens and green card holders. Green card holders are lawful permanent residents. They can file petitions for their spouses and unmarried children of any age. U.S. citizens, however, can also petition for their married children, siblings, and adult children. But here's the catch. These petitions requiring waiting for a visa number to become available. The wait can be months or even years, depending on the category and the country of origin. The government sets limits on how many visas are issued each year, which causes these delays. When family law crosses borders, jurisdiction becomes a key issue. Courts look at where the child has lived for at least 6 months before a case begins to decide which country's court has authority. If parents are in different countries, or if a child has been moved abroad, things get complicated. The Hague Convention on International Child Abduction helps when a child is taken wrongfully from their home country. It allows courts to petition for the child's return, but it does not decide custody. Instead, it focuses on stopping wrongful removals and ensuring the child is returned to the proper court. Enforcing orders across countries is another challenge. A custody or support order from a U.S. court isn't automatically recognized elsewhere. To make it work, parties often seek a mirror order from the foreign court. This is a copy of the original order, adapted to the laws of the other country. It helps enforce the order locally. Custody orders must specify details like visitation schedules, who pays travel costs, and who holds the child's passports. These specifics help avoid confusion and ensure smooth cross-border arrangements. Support obligations also differ across borders. Child and spousal support are usually based on where the child lives or where the parent seeking support resides. But in the United States, support is often based on the parent's connections to the child. This difference can lead to conflicting orders if parents are in different countries. When a parent wants to modify or end support, jurisdiction rules determine which country's court can hear the case. In legal filings, choosing the right petition type impacts how quickly a case moves and what evidence is needed. Filing an immediate relative petition can lead to faster results because there's no waiting for visa numbers. But if that's not an option, family preference petitions requiring patience and planning. For custody and support cases with international elements, understanding which country's courts have authority is essential. The facts of each case, like where the child has lived or where the parents are located, guide these decisions. Knowing these differences helps families navigate the complex world of international family law petitions more confidently.